Understand. The true position is that every provision of the Constitution can be amended provided in the result. The basic foundation and the basic structure of the Constitution remains TLM same. Basic structure may be said to consist of the following features: A. Supremacy of the Constitution. B. Republican and democratic form of government. C. Secular character of the Constitution. D. Separation of powers between the legislature, the executive, and the judiciary. C. Federal character of the Constitution. The above structure is built on the basic foundation, that is, the dignity and freedom of the individual. This is of supreme importance. This cannot by any form of amendment be destroyed. Above foundation and the above basic features are easily discernible, not only from the preamble, but the whole scheme of the Constitution. Yamping dives. I. The provisions of Articles 33, 358, and 359 and the UOE of the words rights conferred in Article 13-2 cannot support the proposition that some of the rights in Part 3 are not natural or inalienable. Righu. India was a party to the Universal Declaration of Right 1, and that declaration describes some fundamental rights as inalienable. Various decisions of this court describe fundamental rights as natural rights or human regao. Kanensinkan. Kesavananda Bharati, Gitalrala, Sikri, CJ. 9. If Parliament who power to pass the impugned amendment acts, there, I want no doubt that the wisdom of the policy of the Parliament cannot be questioned. J-Lut, if the net result of the above interpretation is to prevent Parliament from abrogating the fundamental rights or the basic structure outlined above it, is impossible to appreciate that any uncertainty, friction, or confusion will necessarily result from me. However, it was rightly considered that Parliament could validly amend Article 368 to transfer the source of unending power from List 1 Entry 97 to Article 368, the amendments indicating that the source of amending power will be found in Article 368 itself, and the amendment making it obligatory on the President to give his assent to an RE. Bill duly passed under the article were within the amending power of the Parliament. It is not necessary to go into the question whether Subba Rao, Chief Justice, rightly decided that the amending power was in List 1 Entry 97 or Article 248, because Nad Ting turns on it now. It is not legitimate to interpret Article 368 as permitting Parliament to enlarging its power to amend the Constitution. Clause C of the proviso does not give any different power than what is contained in the main article. The meaning of the expression amendment of the Constitution docs not change when one reads the provision. Article 368 can only be amended so as not to change its identity completely. Parliament, for instance, could not make the Constitution uncontrolled by changing the prescribed two-third majority to simple majority. Similarly, it cannot get rid of the true meaning of the expression amendment of the Constitution so as to derive power to abrogate fundamental rights, if the words notwithstanding anything in the Constitution are designed to widen the meaning of the word amendment of the Constitution. It would have to be held void as beyond the amending power, but they must not be read to mean this. They are inserted to get rid of the argument that Article 248 and Entry 97 list I contains power of amendment. Similarly, the insertion of the words in exercise of its constituent power only serves to exclude Article 248 and Entry 97 list Y and emphasis that it is not ordinary legislative rower that Parliament is exercising under Article 368, but legislative POVRO, amending the Constitution. It cannot be said that if Parliament cannot increase its power of amendment clause, dues of Section 3 of the 24th Amendment, which makes Article 13 inapplicable to an amendment of the Constitution, would be bad. There was no force in this contention. Article 13.2, as it existed previous to the 24th Amendment as interpreted by the majority in Gola Janath's case, prevented legislatures from taking away or abridging the regal JTs conferred by Article 13. In other words, any law which abridged a fund, parental right even to a small extent, was liable to be struck down. Under Article 368, Parliament can amend every article of the Constitution as long as the result is within the limits laid down in this judgment. The amendment of Article 13.2 docs not go beyond the limits laid down 1.5 UICAR. Parliament cannot even, after the amendment, abrogate or authorize abrogation, or the taking away of fundamental rights. after the amendment, a law which, last the effect of merely abridging a right while remaining within the limits laid down, would not be liable to be struck down, 192, 193, 194, Section 2 of the Constitution. 25th Amendment Act, 1971, has been validly enacted. There cannot be any doubt that the object of Section 2 of the Constitution, 25th Amendment,